Hello, this is the Kelso Report's Supreme Court review for the October term 2011, and I'm your host, Clark Kelso. We covered the October term in 4 separate installments, covering constitutional law, commercial and civil law, government law, and criminal law. In this first installment, we'll take a look at the major cases decided by the Supreme Court in the field of constitutional law. But before turning to those cases, let me make just a few observations about the Court's overall performance this term. When you look back at the Court of about 8 or 10 years ago, you see a Court that was pretty reliably split between the conservatives and liberals, with Justices O'Connor and Kennedy serving as the swing votes. There's been a fair amount of turnover on the Court since then, with the addition of Chief Justice Roberts and Justices Alito, Sotomayor, and Kagan. Justice Alito has been a pretty reliable conservative vote, and it appears Justice Kagan will be a pretty reliable liberal vote. Justice Sotomayor has proven to be less easily cabined in, and with the Chief's vote in the Affordable Care Act case, we may be seeing a court that can be split 3-3-3, with Justices Roberts, Kennedy, and Sotomayor being targets for the middle. If this turns out to be the case in coming years, we will be enjoying a much less predictable and much more interesting Supreme Court. Now, the Court had a good number of constitutional issues this term, encompassing decisions involving the taxing power, the supremacy clause, free speech, church and state, the political question doctrine, and preemption. The Court also had the usual number of cases involving Fourth Amendment, search and seizure, and the Eighth Amendment, and I'll cover those cases in the summary of the Court's criminal law docket. Well, without question, the Court's decision upholding the Affordable Care Act was the most important and watched decision this term, so we'll spend some extra time on it. As you know, the Affordable Care Act was upheld by the Supreme Court under the taxing power, while the Court struck down the threat to previously accepted Medicaid dollars as coercive. Now, I think it's fair to say the Supreme Court surprised pretty much everyone in National Federation of Independent Businesses versus Sebelius by upholding the individual mandate in the Affordable Care Act under the taxing power. Before the oral argument, I had forecast that a majority of the Court, led by Justice Kennedy, would strike down the act under the Commerce Clause. While I was correct about the interpretation of the Commerce Clause, a majority of the Court voted that the act was not authorized by the Commerce Clause. I did not forecast that Chief Justice Roberts would then turn around, join the 4 more liberal justices on the Court, and find the individual mandate was actually a proper exercise of the federal government's taxing power by a 5-4 vote. As you know, under the Act, a person who fails to secure insurance under the individual mandate must pay a tax penalty, which is collected by the Internal Revenue Services. Now, the Court's prior cases have always distinguished between the taxing power and the imposition of a penalty, a criminal penalty. So the key question really for the Court was whether the individual mandate and penalty operates as a tax, in which case the mandate was probably authorized, or operates as a penalty, in which case it is not authorized by the taxing power. Even though the Affordable Care Act repeatedly refers to the payment as a penalty, and the supporters of the bill at the time strongly asserted that the act was not a tax, Chief Justice Roberts found just enough indicators in the bill to characterize it as a tax, notwithstanding the contrary statutory language. In particular, the act makes it clear that the only consequence for failing to follow the mandate is the payment of this tax. The amount of the tax is determined by the usual factors that affect taxes, such as ability to pay, and the tax is administered by the IRS. So the Chief held that the mandate was authorized as an exercise of Congress's broad taxing power. Now, a different and larger majority of the Court also held Congress could not force states to accept a significant expansion in Medicaid as authorized in the Act by threatening to withdraw all Medicaid dollars from states that refuse to participate in the expansion. The court held that that condition was coercive. So, states will now have the freedom to decide whether to accept the additional federal monies that go along with the expansion in Medicaid coverage. In California, we clearly will be accepting the additional federal funds. In terms of the development of constitutional law, I think it's difficult to tell right now how important this case may be. On the one hand, the majority clearly has identified a limit to how far Congress can go with the Commerce Clause. But it is not the majority that ultimately carried the day on the Affordable Care Act. Because of Roberts' treatment of the taxing power, the court has effectively laid out a pathway for achieving a form of market regulation under the Commerce Clause that would otherwise be beyond Congress's Commerce Clause power. But that is not actually anything new, since everyone has agreed that the taxing power can affect activity not otherwise within Congress's enumerated powers. Nothing new there. However, I think Congress gets to play this game, the game of telling everybody it's not a tax, only to have the court treat it as a tax, only one time. For the future, there will hopefully be greater political accountability at the time when the measure is being considered by Congress for whether the bill before it is actually a disguised form of taxation. In any event, the court has clearly thrown the ball back into the political realm, and the continued viability of the Affordable Care Act will now become an issue in the fall elections. I suspect public attention is going to turn very quickly away from the court. It already has, even by mid-July, and the public's going to focus on implementation of the act and the politics of the elections. Now, there's been a lot of speculation about Chief Justice Roberts' decision. Just looking at the drafts of the opinions by the justices, it does appear likely that the Chief was originally with the conservatives and then changed his vote at some late date. That change, I think, came late because when you look at the Chief's opinion, it's pretty choppy at times, and it doesn't even have an executive summary at the beginning to tell you what is to come. That is why several news organizations initially misreported the result in the case. There's also speculation that the Chief may have switched votes because of a concern that the court was increasingly being seen by the public as too politically and ideologically partisan in its decisions. Arguably, one way to respond to that criticism is for the court's members to stop voting in ideological lockstep with each other in predictable ways. Now, whether you can accomplish this by having just one member of the court change sides is debatable. Frankly, I think it just amplifies the problem. Instead of voting yes for ideological reasons, every now and then, for no apparent reason, a justice votes no for ideological public perception reasons. If Roberts had pulled at least one other conservative with him, you could say he was leading. When Chief Justice Warren pulled the entire court in Brown v. Board of Education, that was real leadership. But it is not leadership to go off on your own. Then it just looks like you are voting because of political reasons. I don't think, ultimately, we will be able to tell whether the Chief is really moving off in a new direction until we've seen his behavior in a half dozen or more important cases. So it may be 2 or 3 more terms of the court before we can tell whether something unusual is going on, or whether, as is certainly possible, the Chief simply decided at the end of the day, on the merits, and without intending to make any political statement, that the individual mandate really is just a form of taxation. Well, speaking of leadership and unanimous decisions, even though the decision in Citizens United has often been cited as an example of just how political the court has become, the court found unanimous ground for agreement in reviewing a state Supreme Court decision that directly raised the same issue the court decided in Citizens United. In a one-page per curiam in American Traditional Partnership v. Bullock, the Supreme Court reaffirmed that the Supremacy Clause really is supreme by striking down a Montana law that prohibited corporations from making expenditures in support of a candidate or political party. The Montana law had been on the books for a long time, but it was clearly contrary to the Supreme Court's decision in Citizens United. Yet the Montana Supreme Court upheld the law after Citizens United. Well, the Supreme Court's, U.S. Supreme Court's entire analysis is contained in only 2 sentences. Quote, "The question presented in this case is whether the holding of Citizens United applies to the Montana state law. There can be no serious doubt that it does. See the Supremacy Clause," close quote. Getting a unanimous reversal here simply on grounds of the Supremacy Clause is a good example of leadership and nonpartisanship in decision-making. The justices clearly disagree about Citizens United, but they speak as one when a lower court tries to engage in civil judicial disobedience. This year, the court had only one pure free speech case, and it involved the constitutionality of a federal criminal statute. The Stolen Valor Act makes it a crime to falsely claim receipt of military decorations or medals, and the defendant was prosecuted under that act. In United States v. Alvarez, the Supreme Court struck down the act under First Amendment. As you know, content-based restrictions on speech receive heightened scrutiny under the First Amendment. Generally, there must be an important or compelling government interest, and the statute must be narrowly tailored to further that interest. Well, in this case, the court concluded that while the government's interest in protecting the integrity of the Medal of Honor is beyond question, there was no evidence supporting the government's claim that the public's general perception of military awards is diluted by false claims such as those made by the defendant. In addition, the government had not shown why counter-speech, such as the ridicule the defendant received online and in the press, would not suffice to achieve its interest in protecting the integrity of military honors. It should be noted that all of the justices agreed on the legitimacy of the government's interest here. The only real disagreement was whether there were less intrusive means for protecting and furthering that interest. Now, the court's interpretation of the Establishment and Free Exercise Clauses has generally been an area of extreme disagreement among the court's members. But not so this year, where again we saw the court unanimously decide its only religion case of the term. The First Amendment's Free Exercise Clause and Establishment Clause bar the government from interfering with the decisions of a religious group to fire one of its ministers. In Hosanna Tabor, Evangelical Church and School versus EEOC, the court applied that ministerial exception, courts can't interfere with firing ministers, in unanimously dismissing an action brought by a woman who had been formally designated by the church as a, quote, minister of religion commissioned, close quote, following her many years of religious training, as well as a defined process of commissioning. She held a job with the church school as a teacher, and in the course of that job taught her students religion 4 times a week and led them in prayer 3 times a day. She was terminated by the school after an injury left her disabled and unable to perform the duties of the job, and she filed suit under the Americans with Disabilities Act. This was the Supreme Court's first case where it faced the question of whether a particular church employee was a minister or not. That's the issue. So the court expressly declined to formulate a general test, contenting itself instead with the holding that this particular employee fell within the scope of the ministerial exception because of, among other things, the formal title given her by the church, the substance reflected in that title, her own use of the title, and the important religious functions she performed for the church. Now, we next turn to the political question doctrine. That's an extremely narrow basis for the court refusing to entertain certain types of disputes that are to be decided by other branches of government. It is partly an expression of the separation of powers principle. As is typical in political question cases, the court this term rejected application of the political question doctrine and found a way of framing the issue in a traditional judicial framework. Congress had enacted a statute providing that Americans born in Jerusalem may elect to have Israel listed as the place of birth on their passports. Well, the State Department declined to follow that law, citing its long-standing policy of not taking a position on the political status of Jerusalem. When sued by an American who invoked the statute, the Secretary of State argued that the courts lacked authority to decide the case because it presented a political question. Both the District Court and Court of Appeals agreed and dismissed the action. Well, in Zivotofsky versus Clinton, the Supreme Court reversed, with only a single dissenter. The lower courts had framed the case as involving the courts sitting in judgment of the executive's foreign relations power to decide which countries to recognize. The Supreme Court saw the case in simpler terms, as involving only the constitutionality of the relevant statute. The statute may in fact be unconstitutional because it violates the executive's foreign relations power, or it may be constitutional, in which case the executive is bound to follow it. Either way, the determination of a statute's constitutionality is a core judicial function, and the political question doctrine does not apply. The court remanded so that the lower courts could reach the merits in the first instance. We now turn to a series of 3 cases involving preemption. These cases remind us just how much federal legislation there actually is, covering a very wide range of topics, and how common it is to displace state and local laws on same subjects. The Federal Meat Inspection Act. That regulates a broad range of practices at slaughterhouses to ensure the safety of the meat and the humane handling of animals. Federal regulations specify the steps to be taken with respect to non-ambulatory and diseased animals. 3 years ago, in response to a widely viewed videotape, California amended the penal code to provide that no slaughterhouse could buy, sell, or receive a non-ambulatory animal, process, butcher, or sell meat or products of non-ambulatory animals for human consumption, or hold a non-ambulatory animal without taking immediate action to humanely euthanize the animal. In National Meat Association versus Harris, the court unanimously held that the Federal Act preempted California's law. The Federal Act contained a broad preemption clause precluding states from imposing requirements that are within the scope of the Federal Act, relate to slaughterhouse premises, facilities, and operations, and are in addition to or different than those made under the Federal Act. This broad preemption clause was enough to sweep away California's attempt to regulate the same activities and subject matter. Now, from slaughterhouses and meat, we turn to locomotives. The Supreme Court has previously held that Congress had delegated broad authority to the Interstate Commerce Commission under the Locomotive Inspection Act to regulate and approve the design and construction of locomotives and all appurtenances. As a result, a locomotive that is approved by the ICC cannot be the target of inconsistent state regulation regarding design or construction. Applying this principle in Kearns versus Railroad Friction Products Corp., the court held that a state law products liability claim alleging design defect and a failure to warn related to exposure to asbestos was preempted by the federal law. Our final preemption case was another one of the court's controversial decisions. In 2010, Arizona had enacted a statute to increase the enforcement of federal immigration laws by state law enforcement officers. Applying basic principles of federalism as expressed in the preemption doctrine, the Supreme Court, by a 5-3 majority, with Justice Kagan not participating, struck down most of the Arizona statute. First, the court struck down a new state criminal statute making it a misdemeanor willfully to fail to complete or carry an alien registration document concluding that Congress had occupied the entire field of regulation dealing with alien registration, leaving no room for state regulation. Even the Arizona statute, which simply added a state law penalty for conduct already proscribed by federal law. Second, the court struck down the statute which made it a misdemeanor for an unauthorized alien to knowingly apply for work, solicit work in a public place, or perform work as an employee or independent contractor in Arizona. There was no federal counterpart for this statute, and the court held that it upset the federal balance that was intended to be achieved by the Immigration Reform and Control Act of 1986. Third, the court struck down the provision that authorized a state officer without a warrant to arrest a person if the officer has probable cause to believe the person has committed any public offense that makes him removable from the United States. That provision created a local enforcement mechanism that is entirely outside the elaborate system created by Congress dealing with removable aliens, and is therefore preempted. Finally, the only provision upheld for now is that portion of the Arizona Act which requires state officers to make a reasonable attempt to determine the immigration status of any person they stop, detain, or arrest on some other legitimate basis, if reasonable suspicion exists that the person is an alien and is unlawfully present in the United States. On the record before the court, there was no evidence that this provision would interfere with federal immigration enforcement activities, and in fact, the states are generally encouraged by the federal government to make use of immigration status checks. In addition, there was no evidence that detainees would be detained for any significantly additional period of time in order for status checks to occur, a delay that the court warned might well raise constitutional concerns. So the court held the status check portion of the law is not preempted for now, but implementation problems with a status check might well change that result in the future. In short, it is a near total loss for Arizona, and depending on how the status check process works, it might turn into a complete loss. The federal government remains supreme when it comes to immigration policy and enforcement. Well, that's it for our constitutional cases. Note that in the vast majority of these, the cases aren't even close. And we don't see votes along stark ideological or partisan lines. We saw most of the cases decided by wide margins, many of them unanimously. And that somewhat puts the lie to the notion that the Supreme Court is routinely engaging in ideological and partisan decision-making. Well, we'll see what happens next year with Chief Justice Roberts, and see whether he continues to strike out on his own in various cases. And we'll have to see if we can identify a substantive basis for when he is likely to strike out on his own. That's it for this portion of our Supreme Court review. Have a great day in the law.